What gives a government its power? This question, central to much of Enlightenment political thought, would cause a dramatic and unprecedented shift in the structural balance of political influence. An upset of millennia of monarchic rule would see ideas of Thomas Hobbes, John Locke, and Jean Jacques Rousseau, and other key thinkers, adopted by mass movements for revolution and social upheaval. So, what was their answer to that great quandary? To understand their response, we must first delve into the underlying principles which they deemed key to the human experience. The roots of these can be found in interpretations of writings by classical Greek and Roman philosophers, chief among them being Aristotle. Although interpretations of his works differ, and often come under scrutiny, it can be taken that Aristotle believed in a difference between the universal law of nature, or natural law, and those instituted by governments, known as positive law. Similarly, Cicero found that nature is the origin of the justice and laws which humanity embraces, and that natural law was not only for the purpose of serving the wider collective, but that laws which failed to do so were essentially worthless. In line with these ideas, theologian and philosopher Thomas Aquinas determined that the divinely created world and the people within it were beholden to theological morals. These guidelines from God were taken both from biblical interpretations and from rational observation of nature, informing an understanding of the world in which humans were actors who must fulfill God's plan for themselves and the world. According to Aquinas, in Lex Naturalis, the unique aspects of human intelligence and virtue which God bestowed on us were invaluable, and were the cause for both our natural laws and the incentives for their upkeep. Due to the somewhat unfirm foundations of natural law theory as presented in this way, of having no greater directive or responsibility than to conform to the supposed directions of God, later scholars would have to challenge the bases of Aquinas' suppositions while maintaining their outcomes. The Enlightenment thinker and Dutch statesman Hugo Grotius would find a much tighter explanation for natural law and its virtues. Grotius saw natural law as a result of human nature, specifically, that humans' inclinations towards self-preservation and society were the two foundations on which moral law stood. Therefore, in Grotius's view, it was human rationality that determined an action's morality, as a natural good would necessarily work positively toward people's self and community. As a natural extension of the inherent value imbued by God or nature into a person, the existence of natural rights which a person must possess to fulfill his duties towards natural law were self-evident. These rights were not to be removed by any laws of man, or those created by kings or rulers, and were equal among all people. This concept of natural rights would form the crucial basis of an idea which would shake the political framework of Europe and the world at large, social contract theory. In its most basic sense, the social contract describes a compromise between nature and order. In a person's natural state, he possesses all rights granted to him by nature and acts entirely in his own interest. However, there is an alternative to this archaic state of nature, that being cooperative society. Social organization requires that people not fully enact their own free will, since limitations exist between what people may do to each other, but each member gains the advantages of societal efficiency and collective effort. This agreement between a society's members, that they will sacrifice true freedom for the preservation of a good, ordered society, is known as the social contract. A thorough account of each Enlightenment philosopher's contributions to the ideas of natural rights and social contract theory would be rather unwieldy, so we will now examine those of just four. One of the most influential minds behind the social contract, who popularized the social contract theory in his groundbreaking publication Leviathan, was Thomas Hobbes. Hobbes placed great value on social structure, claiming that a true state of nature would involve the loss of not only certain benefits of governmental law and order, but the entirety of civil production and efficiency, to the point where complete individual freedom would leave those individuals in a state of primal, animalistic living. Hobbes also saw individuals in a rather pessimistic light, believing that they act almost entirely for self-preservation and their own interests, with little regard for community aside from their immediate family or circle, and would deem their actions less on true moral standards than by personal judgments and justifications. With this perception of humanity, Hobbes concluded that a true state of nature would result in the pitting of each's interest against every other's, making more of a state of war without any authority to resolve these disputes and transgressions. In keeping with natural law theory, Hobbes believed that rationally acting people would generally support peace as a measure which benefits themselves, but still fretted over the implications of their freedom to act otherwise. Hobbes supported this idea of the natural human condition through observations of how states acted amongst themselves and between each other, causing wars and civil breakdowns, although his overarchingly negative view on humanity is the continued subject of much scrutiny and criticism. It's with this state of nature in mind that Hobbes opposed the virtue of social organization for the sake of mutual protection. Hobbes saw fear as the chief motivator for the formation of a social contract, and therefore viewed societies created both from collective agreement among common authority and between those created under direct threat by a greater power as equally legitimate. Hobbes's primary criterion for the legitimacy of a regime was not its conditions of its creation, but its utility in protecting the community and maintaining individual rights against those of the other. Because Hobbes viewed government as a tool for effective organization and protection, he was also strongly in favor of absolute monarchy, believing that the power of one ultimate authority was the best way to ensure protection of a people and swift correction of its faults. In light of social contract theory's wide reaching consequences for monarchical power in later years, it's rather ironic that Hobbes made his arguments so staunchly in favor of just those systems. Another Enlightenment thinker, and one of those who would shift the social contract's paradigm into an opposition to monarchy, was John Locke. Locke viewed natural law and rights as more dependent on rational arrival than divine instruction, contrary to prior philosophers, and famously affirmed life, liberty, and property as those inalienable rights, although his views on property have been contemporarily scrutinized, and the idea itself was omitted and replaced when adopted into the Declaration of Independence with an equally ambiguous true meaning. Contrary to Hobbes, Locke stressed consent of the governed as the central authority through which society and government may be justly instituted. Locke's view of the social contract requires that members expressly choose to participate in such a society, and given this prerequisite, most governments would be seen as illegitimate if taken to his philosophy's extremes. To combat this conclusion, Locke explained that a person's authority to be governed and to leave the state of nature were granted upon his participation in a society, not just its foundation. Given this, the legitimacy of a government, much like in Hobbes's view, is derived from its efficacy in governing and its alignment with natural law. Locke also emphasized that a proper government's power should be separated into legislative and executive branches with separate abilities to create laws and to uphold them, although there could be variance in the application of this principle. Though not prescribing a particular government or constitutional form as that which would be necessary for a just government, Locke also makes it clear that, contrary to Hobbes's ideas, the people were the ultimate source of a government's authority, and were entitled to rebel against unjust rulers. Given that Locke had lived through the English Civil War and the Glorious Revolution, each which saw shifts in power between standing monarchy and its challengers of Oliver Cromwell in the former and William of Orange in the latter, it's easy to see why he would adopt this position. This important conclusion, that the people may dissolve, institute, or alter governments as was the general consensus and in line with natural law and rights, would form the bedrock for later philosophies of Jean-Jacques Rousseau. Taking great issue with the tyranny of monarchy, Rousseau focused his view of the social contract on its role as a way to avoid both the chaos of true natural freedom and the transgressions of supreme authority. Similarly, he saw the contract as an incarnation of the general will of the people, and as its power coming not entirely from natural law, but from general communal interest, and that people in a society are ultimately beholden to the general will in their behavior. In the same way, since people are uniquely rational agents, and their freedoms granted by natural law are good when not contradicting those of others, a just government must only protect the freedoms of its peoples to the extent necessary to protect those people, and it can only revoke certain rights insofar as they are voluntarily placed under that government's trust. In Rousseau's ideal state, the general will would constitute a government such that a people, while subject to its own laws, are free from being subject to any particular person's will over their own, since the government would be formed of collective agreement of participation of all involved citizens. Rousseau holds somewhat contradictory views on the legitimacy of representative government, which leads to difficulties in determining the proper form of such a government, but he's quite staunchly against monarchy in his writings. This principle leads Rousseau to the same conclusion as Locke's. Citizens of an unjust, unnatural government are both allowed and obliged to overthrow or revise that government. It is for this reason, along with Locke's agreeing sentiments, that these two philosophers came to such prominence in the ideas of revolutionaries throughout the 18th century and beyond. Just as, if not more, influential than Rousseau and Locke in determining the mainstream philosophies of natural rights and the social contract was Immanuel Kant. Going against Locke's specifications of life, liberty, and property as key natural rights, Kant believed that the only intrinsic right of any person was his freedom, and particularly his freedom against others' wills, and to this extent, he saw just governments as only pertaining to the protection of freedom and not to the upholding of arbitrary moral standards or measures of happiness. This libertarian view on government's purpose enables minimal coercion and power for the state and as much individual freedom as can be maintained amongst citizens. In line with Hobbes and Locke, Kant explains that the social contract is a general social idea, rather than a specific binding agreement which historically occurred in any given state, and is similarly the result of people choosing to exist within a society rather than to institute one. However, he also saw the social contract more generally as a societal convenience for overall freedom rather than binding ties between individuals for the benefits of each, and thereby aligns himself more closely with Rousseau's ideas of the general will. However, he differed from Rousseau majorly in his views on republican governance. Kant saw great value in representative government, and not only saw representatives as more worthy of their power than Rousseau did, for the sake of representing public interest, but as generally more worthwhile as mechanisms for political action than individual participation in legislation. Although these philosophers often had great differences in the specifics of their views, their overall writings provide the same answer to our question posed at the beginning of the video. A government's power comes from its people. In direct contrast with the dominant idea of divine rights of kings, these Enlightenment philosophers, for the most part, deemed monarchies to be an abomination in the political landscape. To those who took the social contract to heart, monarchies failed in almost every aspect to deliver the type of government that nature demanded. The results of this stance were key throughout the late 18th century, most importantly in the American Revolution and the French Revolution. Each of these were directly influenced by Enlightenment ideas of natural rights and the social contract, particularly by John Locke and Jean-Jacques Rousseau. The former had his specific words, though somewhat altered, used in the American Declaration of Independence, and principles of natural rights became imbued in privileges of the French people through the French Constitution and the Declaration of the Rights of Man. The idea that government arises from the consent of its governed gave revolutionaries ground to break free of their colonial overseers and similarly fought against monarchic rule in France and later across Europe more generally as time would go on. The further these ideas spread, the more they challenged standing powers in Europe, slowly creating our modern world with few reigning monarchies left in existence. Though arising from Catholic principles which aligned originally with the dominant powers of the Middle Ages, the Enlightenment principles of natural rights and the social contract would ultimately lend credence to widespread democratic republican ideas.